will be punished for slander, you know, outside of school, but not government concern. It makes sense in a brain.
So slander is not protected speech. It's not protected by the First Amendment, and so you can be civilly liable for a tort of defamation or slander if you make a factual statement, a representation of the fact that adversely affects someone's opinion, that adversely affects someone's reputation. So that's not protected speech.
But why can't, like, with, you know, with what people say, why can't that just be considered slander? Does that make sense? Kind of.
So why can't we?
What's the question?
I think let me try the question. Is the question why can schools punish the nasty comment as because it's slander rather than bullying? But sometimes it's not slander because slander, if you say an opinion, that's not slander. Like if I call you, you know, an effing a-hole, that's not defamatory. It's just an opinion. So you could have opinions that end up adversely affecting someone's educational environment that wouldn't fall under the constitutional definition of slander. There are also true threats. That's not protected speech, but the standard to get to a true threat is pretty high. So there are all kinds of speech that are short of these categories. There are certain categories of speech that are not protected by the First Amendment. Slander, true threats, by the word. They're pretty hard to read that, and there's a lot of bullying that happens that's not one of those exempt categories, but that still can have a different student.
Well, I'm really concerned more actually about the substantial disruption when it comes to the harassment situation, use of speech, because the problem is that in applying Tinker is those, when it has to do with political speech done in a public forum, then you immediately have that question of the disruption of school activities and so forth. But the kind of thing we're talking about, for example, the client you mentioned, that is done one-on-one, and often is usually the victim is certainly not going to advertise what's going on, and neither is the perpetrator. So how can you claim that? How can you use the Tinker standards, because there is no substantial disruption of the school day?
Well, it's substantial disruption of like educational environment. So I think if it substantially disrupts an individual student's educational opportunities or ability to go to class or school performance, then I think it would fall. Let's say that the speech definitely occurred on campus. So we don't have this on campus. This question. But Tinker has actually two problems. One, if there's a substantial disruption of the educational environment, which I think you can define broadly as like the entire school is thrown into chaos, or an individual student's educational environment is disrupted. But Tinker also says that the schools can punish speech where it invades the rights of others. And so if
it would be more under that.
It would be more under the invades the rights of others problem. But I think the difficulty is that like these tests are very elastic, and judges, the reality of course is that judges reach the results they want to. So you have cases where all manner of chaos breaks loose, and the court wants to find that like love and wasn't really substantial disruption, or you have this like horrible experiences the student went through with like harassment, and the judge will say, oh well, that's just like ordinary insult on the playground. We shouldn't be like policing PC stuff in the federal courts. So the substantial disruption test is kind of elastic in and of itself. I mean, that's what we see as practical error.
Thank you.
Linda, if you want, you have other things you want to say, and we'll give more questions and answers after that.
Okay. This is like halfway through my outline.
Yeah, okay. That's what I thought.
So anyway, I'll just try to wrap up on the free speech section, which is that, unfortunately, this is not a very insightful comment, but you certainly don't have to go to law school. But judges have to choose results they want to, like whether they apply Tinker, whether they don't apply Tinker. What we tend to see is that if it involves violent speech, the court will find a way to say the school can punish it. If feasible that increasingly what you see is that bullying might happen purely through electronic communications and not based on in-person interactions. Or the in-person interactions are sort of, if you just looked at the in-person interactions, you wouldn't know all of the context of what's going on. That's all the actions on like the texting. So I think a huge conceptual question: what is off-campus speech? What is on-campus speech? Does that distinction make sense in the electronic era? If we can agree that some speech is off-campus, what's the legal standard that should apply? If we can get past the if, then it's very clear to me that the legal standard should be much more protective than tinker, because out in the real world, beyond schoolhouse gates, we have introduced pretty strict scrutiny. We don't regulate speech based on the possibility that it might disrupt something or that someone might be offended. That is like First Amendment 101. You don't disrupt speech based on listener's reaction. So it has to be something, if it's clearly off-campus speech, it should be regulated by a higher, more speech protective standard. And then I think another difficult question is, if it is clearly off-campus speech, should it be the school that regulates it, or should it be someone else? I personally, this is on YouTube, so this is exciting. This is not actually officially sanctioned ACLU policy. I personally think that when you're dealing with the harassment and bullying context, you do obviously want to encourage the school to take proactive measures to build a climate on campus of inclusion and respect for diversity. But in those very extreme situations, the school doesn't have the full panoply of tools to deal with it, and we would rather it be the school that it be the one dealing with the bullying than the police. We don't endorse school to prison pipelines, so we don't want to move the response to bullying away from schools and towards the police. I think that would be a dramatically bad policy term. So that's my 2 cents on bullying. If we have time, I'd love to talk about law enforcement on campus, but I think nobody's expressed it. How are we doing on time?
We're doing okay. Take another 10 minutes, and then we'll have probably more questions. Because I think there are more questions, but I thought we'd give you a chance to help you out.
Okay. So, searches and seizures. I just want to do a quick shout out to my colleague Michael Risher, who won a great student search and seizure case last fall on student drug testing. So one of the great things about being in California, one of many, is that we have this fantastic state constitution that's more protective than the federal constitution. Under the federal constitution, the U.S. Supreme Court has made clear that schools can engage in suspicionless drug testing of athletes in schools, and they can engage in suspicionless drug testing of students in competitive extracurricular activities. So, based on that, the Shasta Union, or Unified School District up towards Reading, implemented a suspicionless drug testing policy, and we had some great activist families who got in contact with us. One of our plaintiffs was Brittany Dalton, who was a competitive flute player, and so they were going to make her and like the 4-H club and like the choir and the band, all of them were going to have a peanut cup if they wanted to participate in extracurricular activities. And just on principle, these students and their families thought that that was an invasion of their privacy rights. So we brought a claim under the state constitution, because we have no claim whatsoever under the federal constitution, and we won in a fabulous decision. And it was just in time. We got a preliminary injunction. Because Brittany Dalton, our competitive flute player, had made, she had competed and made it to the finals, but they weren't going to let her compete unless she peed in the cup. And we were going to try to, like at the hearing, we were trying to get the district to just agree to make her give an exception, and they wouldn't. So the judge said, fine, I'll issue a preliminary injunction, or pull photos and joined. And then Brittany went on to compete, and she her team won. So that was really wonderful. And the Court of Appeals affirmed that decision. A very good decision from the trial court, so that's a great victory. Two really interesting cases that were up in front of the Supreme Court dealing with law enforcement on campus. One involves the rights of what happens when the police come onto campus to interview students when A, the student is a suspect of, and B, when the student is not a suspect but a witness. So the general principle of doing search and seizure law out in the world, you have the police have to have probable cause in order to engage in a search or a seizure. The standard, similar to the tinker sort of dynamic that we're seeing, is that, well, in the school environment, we're going to give the school officials a lot more latitude. So the school officials don't need probable cause, they only need what's called reasonable suspicion, which is a much less rigorous standard. But if a school official has reasonable suspicion violated a school rule or a law. Unfortunately, the California courts have applied this reasonable suspicion standard not just to school officials, so not just to the teacher and principal, but also to school resource officers. So these are like the police who are like loaned from the Davis Police Department to walk around on campus. They're, fully named officers, peace officers, and they're doing criminal law enforcement, but they get to benefit from this lower reasonable suspicion standard. So, interesting case involving Miranda rights. So this is less on this reasonable suspicion, but you've all seen TV. So under the Fifth Amendment, we have Miranda rights. And so once you are brought into a custodial interrogation, you have to be given warnings to advise of your constitutional right to remain silent, to have an attorney, blah, blah, blah. So but that is only triggered when you are put in what's called custodial interrogation. And it's kind of one of those, like, I know I'm going to see it things in the courts. But custodial interrogation, the basic test is, would a reasonable person sort of felt like they could go, or did they feel like they really were, detained? So, interesting case out of North Carolina that the U.S. Supreme Court just decided today. There was a 7th grade student, special ed, who was questioned at school by a police officer about a string of robberies in the neighborhood. And after being badgered for at least half an hour about how he could end up in juvie, unless he cooperated, what did he do? What any person would do in that situation, and certainly what a 7th grade special ed student would do, he confessed. Guardian hadn't been contacted, and it was clear that they had not given him any kind of warnings whatsoever that he had a right to contact someone and he had a right to remain silent. North Carolina Supreme Court said, nah, we're not going to suppress that. And it doesn't matter. We're not going to suppress that because he wasn't really in a custodial interrogation. He could have left. And the fact that he was young does not influence our analysis of whether he would have felt like he could have left. Justice Sotomayor, I love saying that, wrote the opinion for the court and said, you know what, age does matter. Because in any other context of the law, we have this reasonable person standard, and a reasonable person is always a reasonable person in the shoes of that person. So you're not going to take what an adult would think in that situation. You're going to take the reasonable perspective of a 7th grade student. And so yes, we figure age into the analysis of whether someone would have perceived themselves to be in custodial interrogation. And yes, age matters. So they sent it back to the lower courts to analyze the facts under the correct legal standard. So that was a very good decision